Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Justin Baldoni and the Wayfarer parties have just filed a new motion to compel some information from Blake Lively, so I'm going to run through that with you real quick. Alright, so the parties are requesting an order compelling Blake Lively to provide within 7 days a computation of her alleged damages, the theory under which she seeks damages, and the documents supporting the computation pursuant to Rule 26 and a bunch of letters. B, a verified response to an interrogatory seeking a computation of each category of alleged damage, the damages interrogatory. And C, documents relating to her claims for damages, including but not limited to documents sufficient to show her net worth, such as financial statements, assets, and liabilities. Miss Lively must comply with Rule 26 and a bunch of letters. Sorry, I'm not saying all that. Rule 26 requires parties to provide a computation of each category of damages claimed by the disclosing party, who must also make available for inspection and copying, as under Rule 34, the documents or other evidentiary material, unless privileged or protected from disclosure, on which each computation is based, including materials bearing on the nature and extent of injuries suffered. The fact that plaintiff's damages computation might be complex and lengthy and involve a lot of documents does not excuse plaintiff from complying with the requirements of the rule. The Wayfarer parties are also entitled to know Miss Lively's theory of damages. Courts examining this issue have held that Rule 26 and a bunch of letters requires more than merely setting forth the figure demanded, and that it contemplates an estimate of damages and some analysis. Miss Lively was obligated by Rule 26A to disclose her damages voluntarily, for example, without awaiting a discovery request. Furthermore, even assuming Miss Lively produces documents concerning her alleged damages, which she has not done, she is not excused from her separate obligation to disclose a computation of damages. She should be compelled to do so. Miss Lively's excuse for violating Rule 26 is that an expert will calculate her purported damages on an unspecified date, but presumably prior to the October 15th deadline for the completion of expert discovery. However, the obligation to disclose a damages computation is separate from expert discovery obligations. And they're citing a case here that says the mere fact that assessing the amount of damages will require expert testimony does not absolve U.S. Bank of providing in its initial disclosures a computation of damages using the best information it has available. The damages interrogatory, as narrowed by the Wayfarer parties, is limited to requesting a computation of Miss Lively's alleged damages, which complies with Local Civil Rule 33.3a. Miss Lively refuses to respond to the damages interrogatory on the grounds that the information sought is the subject of expert discovery. However, under the local civil rule, Miss Lively is obligated to respond to the damages interrogatory based upon the information presently available to her, and she can supplement her response, as appropriate, after expert discovery. Miss Lively's amended complaint alleges that she suffered substantial losses in earnings, equity, and other economic losses, and significant general, actual, consequential damages including lost earnings and other pecuniary loss. She also alleges that her businesses, Blake Brown, Betty Booze, and Betty Buzz, have been damaged. Oh, they've been damaged, but that's through no fault of anyone else. The Wayfarer party's document request number 56 seeks all documents and communications relating to Miss Lively's claim for damages. However, Miss Lively has not produced any documents or communications responsive to document request 56. Although Miss Lively claims she will eventually produce such documents, the deadline for substantial completion of document discovery has passed. She has not produced any responsive documents and has not confirmed when she will do so. The court should compel Miss Lively to produce all documents and communications concerning any damages she alleges have been incurred by her or her companies. The Wayfarer party's document request number 254 seeks documents sufficient to show your net worth for the period between January 1st, 2022 and the present, including, without limitation, financial statements, assets, and liabilities. Miss Lively's position is that such documents are irrelevant to her damages claim. This court has already determined, in this case, that documents sufficient to show net worth are relevant to a party's claim for damages arising out of tortious conduct. If the Wayfarer party's then existing claim for defamation and resulting damages mandated the disclosure of their net worth documents, as this court previously determined, and as the Wayfarer parties have since disclosed in compliance with the order, then Miss Lively's net worth is relevant to her defamation claim, her other claims, and the substantial damages she seeks in connection therewith. I mean, yeah, that makes sense. We respectfully request that the court direct Miss Lively to provide within 7 days a computation of her alleged damages, the theory under which she seeks damages, and the documents supporting the computation, a substantive response to the damages interrogatory, and documents responsive to the damages requests. I think I saw them citing a Fritz declaration in here, but I did not actually see that on the docket yet. Maybe it's just not showing up, or maybe I missed it. I don't know, but that's all I got for now, guys. Thanks for watching. Let me know what you think in the comments below, and I'll see you all soon.